Good morning, everyone, and thank you for attending today's SAVAT SART training. My name is Summer Gaines Wheeler. I am the Sexual Assault Forensic Exam and Sexual Assault Response Team Policy Advocate with MCASA. And for today's training, I will be presenting on the role of the Forensic Nurse Examiner, also known as the FNE. And like Alyssa said, if you guys have any questions, feel free to leave them in the chat, and I or another MCASA staff member will try to answer them as best as possible. Okay, so to get things started, I wanted to provide a brief overview of what a SAFE is. A SAFE is a sexual assault forensic exam, and it is a procedure that provides survivors with important medical care and allows for the collection and preservation of potential evidence. A helpful way to understand a SAFE is to separate it into two parts. You have the medical attention portion, and then you also have the evidence collection portion. To go in depth, the medical attention portion includes elements such as checking and treating for potential injuries, providing STI prevention treatment and or testing, as well as pregnancy prevention, such as offering emergency contraception pills like Plan B. And the evidence collection portion includes taking photos of injuries, collecting DNA, as well as collecting clothing items. And it's important to note that in the state of Maryland, safes conducted up to 15 days after an assault occurred will be reimbursed. And the new law does not specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. So, when understanding the process of receiving a SAFE and reporting sexual assaults, it's important to understand the different options that are available to survivors. Survivors have options when choosing to report a sexual assault either to the emergency department, law enforcement, and or the rape crisis center / advocate. And it's possible that survivors reporting to the emergency department may choose not to receive the SAFE and simply receive medical treatment instead. If they choose not to receive a SAFE, advocate presence should still be offered. Likewise, child protective services and adult protective services are called in cases that involve child sexual abuse or cases that involve vulnerable adults. And vulnerable adults, according to Maryland's Office of the Attorney General, are people over the age of 18 who lack the physical or mental capacity to provide for their daily needs. So just ensuring that we have necessary resources and available support systems to survivors is always important in this job. Okay, so now moving on to advocacy as this really pertains to your guys' role. Advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including in the exam room. So I kind of want to talk about what occurs during each stage. So before an exam, advocates can work to address acute concerns identified by the survivor, work through any questions about the exam process, explain their role in services, as well as review potential reporting options. During the exam, advocates can help support the survivor through any / all parts of the exam, including offering grounding strategies, co-regulating, offering encouragement, as well as empowering the survivor to choose from the different exam options. An important note to be aware of is what to do if you are invited into the exam room. So, for example, please do not speak for the survivor. Please don't touch any of the nurse's tools. Overall, it's best practice to understand and remember your physical place as well as space in the room itself. It's also equally important to be prepared to ask the survivor if they would like any privacy or for you to stay during the various parts of the exam. For example, you may encounter some survivors who want your physical presence during the narrative portion of the exam, but may request privacy during a speculum exam and or during any portion of the evidence collection. After the exam, advocates can work on a safety plan for the post-crisis intervention period, connect survivors with ongoing advocacy or community referrals, as well as address any ongoing concerns that the survivor may still have. Additionally, the safe hospital should have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. Advocates can work with forensic nurse examiners and potentially law enforcement to ensure a timely, survivor-centered, coordinated response to the hospital. And another important note that I really want to emphasize is that a survivor may choose to have an advocate present at the hospital, even if they choose not to have the sexual assault forensic exam completed. Likewise, survivors are not required to have an advocate present and may choose not to. In this situation, an advocate can provide contact information or any other relevant community referrals for the survivor to reach out to if they want to in the future, right? So we really just want to ensure that we are respecting the survivor's wishes and allowing them to have the autonomy to make decisions for themselves as they feel is best in that moment. So now I want to go a little bit more in depth about what occurs during the exam. So a safe exam includes several important elements, including a detailed interview conducted by the forensic nurse, a body exam, evidence collection, photographs, as well as documentation of findings. And it's important to note that a survivor can choose not to receive any portion of the exam at any time. Additionally, during the interview, survivors can disclose what they choose to about the assault. However, an advocate can gently encourage details as it will impact medical prescriptions and evidence collection. So, as mentioned before, just ensuring that we are supporting the survivor as best as possible without pressuring them or making them uncomfortable. And just wanting to ensure that we are allowing them to make decisions for themselves as they feel it's best. And lastly, the exam can last anywhere between 3 to 6 hours. So I believe my colleague will talk about this a little bit more in depth in their presentation, but this can be a very invasive exam and it can be very difficult for survivors, right? And it's a long time. So there's occasions where we want to allow the survivor to take breaks, get water or whatever, just ensuring that the survivor has the ability to take care of themselves during this process. So during the exam, the forensic nurse examiner will look for bruising, wounds, and other injuries that may have occurred during the assault. And if any injuries are present, the forensic nurse will then use photographs to document the wounded areas, as you can see on some of the examples on this slide. Now, there are also cases where injuries may not be visible, for example, in strangulation cases. In these instances, an alternate light source may be used to photograph the areas. And an alternate light source is essentially a technique that can detect bruising or injury that has occurred beneath a skin layer and is not available to the naked eye. A forensic nurse will also use cotton swabs to collect evidence from various parts of the body, including the skin, inside the mouth, and underneath the fingernails. A genital and anal exam are also completed, in which a forensic nurse conducts both internal and external swabs of the area. Now, the areas that are swabbed are based on the victim's narrative of the assault provided to the forensic nurse examiner. And this is why providing details may be especially important, as it can guide evidence collection and increase likelihood of obtaining DNA. So as we've mentioned before, and as we've learned before, as an advocate, one should never speak for the survivor or force them to provide more details than they are willing. However, supporting them during this process and really helping explain to the survivor why it is important and valuable to provide details may be beneficial. So the next thing that I want to go ahead and discuss is what occurs after the exam. So it is important to mention that sexual assault forensic exams are free of cost with or without insurance because they are government funded. So additionally, the forensic nurse examiner or advocate available will inform the survivor about community resources available to them, including counseling or any support groups. And the survivor will be offered, as mentioned earlier, emergency contraceptives, STI prophylaxis, HIV prophylaxis, free of cost. Additionally, the exam is free, and I really want to reiterate that this is free regardless of the survivor's decision to report to law enforcement, right? So the main idea here in this presentation is really ensuring that survivors are having compassionate and accessible care to the resources and support that they need and deserve. So, there are several things that a survivor can do to best preserve evidence before getting safe completed. For example, you guys might be familiar with this, but not changing clothes is important because the survivor's clothes will be collected into evidence during the safe. If the survivor does change clothes, they should bring the clothes with them to the hospital. It's also advised that they refrain from using the bathroom, eating, drinking, or brushing teeth. Additionally, refraining from showering or bathing beforehand is also advised in terms of evidence preservation. However, I do want to emphasize that if a survivor has done any or all the previous listed activities, do not discourage them from getting a safe. The forensic nurse examiner will still attempt to collect evidence, right? We can't expect survivors to be fully knowledgeable in terms of what to do after an assault, nor should we expect them to prepare for that sort of trauma-related event. So we want to still encourage them to have as much evidence collected as possible. And the last thing that I want to show you guys is a video that really discusses the value and importance of advocacy during a sexual assault forensic exam. So as Alyssa mentioned, a lot of the material that we're covering today is sensitive, so I just wanted to give that content warning. But it really does serve as a useful tool in understanding advocacy during the exam. Just as a reminder, or as a note, I should say, the video is not super loud and there aren't any closed captions available, so I apologize for that. But if you guys just need to turn up your volume on your end, feel free.
Rape is a reality across the globe, including right here in Chicago. For survivors, support is crucial on their road to recovery.
I'm an 11-month survivor of rape.
According to the CDC, 1 out of 5 Illinois residents have reported a rape. One local organization seeks to help victims of sexual abuse by providing immediate, round-the-clock support in 14 area hospitals.
Essentially, if a victim of sexual violence shows up at any of those hospitals, the hospital pages us, we dispatch an advocate, it doesn't matter what time it is, and that advocate is there really solely for the victim.
During a traumatic time like this, you are not able to think or understand what people are saying. So it helps to have someone there to be supportive, to actually advocate for you and help you navigate through the system, and to provide you with all of the services that you're entitled to based on the law and based on what your needs are.
The survivor we spoke with was raped while on a date, and unfortunately, she is not alone. 2 out of 3 reported rapes are committed by someone the survivor knows. Sharmili says it's crucial to let survivors know you support and believe them early on in the process.
When I was in the emergency room, I was asked if I wanted an advocate, and I said yes. So my advocate, Providenza, showed up within an hour. It was just so reassuring to have somebody who believed me and was on my side.
There's actually been research done that shows that having immediate care right after someone is assaulted and in an emergency room setting actually improves the ability of the person on their road to recovery in terms of their emotional healing but also in terms of their case being taken as seriously as possible.
If I had not had an advocate, I would not have been aware of the civil no contact order that I was able to get temporarily. I would not have known about Illinois law that funds the ER visit and the follow-up care. I wouldn't have pursued probably therapy on my own to help heal, and that was such an important piece of healing.
When it comes to making societal changes, seemingly small steps can make a big impact.
Most likely, there are people in your life who are survivors of sexual violence that you don't even know about. There are people that you hang out with, there are people that you go to school with, there are people that you work with. Part of what we're hoping is that people will talk a little bit more about the issue of sexual violence, because all of us are bystanders in some way. And so we have the ability to interrupt behavior, language that supports sexual violence. Rape jokes are not funny, for example, and things like that actually create an environment in which victims don't feel like they can come forward, and the people who perpetrate feel like they kind of have license to do what it is that they do.
The survivor we spoke with has a message of her own, one that is clear and simple.
No is no. Anything other than yes, let's do this is no. No matter what age or how I'm dressed or what time of night it is or how much I had to drink, I am a human and I deserve to be treated with respect.
Sexual assault is a traumatic event, but there is hope.
I am so much stronger than I think I am because I survived this. And not only did I survive, I'm thriving. I grew through this process. It was painful and it hurt so bad. And there were some really low lows, but I survived. If one person who sees this segment can benefit and seek the help that they need to heal from this, then my assault won't be in vain.
If you or someone you know is a victim of sexual assault, please contact the 24-hour Chicago Rape Crisis Hotline at 888-293-2080. For more information, head to our website, livinghealthytv.com.
All right, so that concludes the end of my training on the forensic nurse examiner. As we've mentioned before, if you guys do have any questions, feel free to put them in the chat and I or another staff member from MCASA will try to answer them. I also listed our contact information. So I appreciate you guys taking the time to listen to this training, and I hope that it was beneficial and informative. And I will now hand it off to my colleague Cameron to conduct the law enforcement role. Thank you.
All right, so just give us a moment while we get Cameron set up.
Okay, can you all see my presentation? Awesome. Okay, so hello everyone. I am Cameron Dewey and I am the Sexual Assault Response Team and Sexual Assault Kit Initiative Policy Advocate with the Maryland Coalition Against Sexual Assault. Today I am going to be talking about the role of law enforcement and how they collaborate with victim advocates to serve and support survivors. Full disclosure, I am not a law enforcement agent and I never have been, and I do not claim to have that lived experience, but this is a high-level overview of how law enforcement engages with survivors and victim advocates. So first, I'm going to talk about our goals and objectives. There are three main ones. The first is to review how law enforcement receives and responds to reports of sexual assault. The second is to review the role of law enforcement regarding the interview and evidence collection process. And the next is to understand the role of the victim advocate during the investigation. So first, I want to talk about sexual assault reporting. When considering reporting methods for sexual assault, there are several ways law enforcement may receive reports of sexual violence. The first is through hospital personnel, and this occurs when a victim goes directly to a hospital for a sexual assault forensic exam before they contact law enforcement. So when they arrive at the hospital, they are given the option to inform law enforcement and report the assault, but they are not obligated to, and this will not impact their right to a safe exam. If a survivor would like to involve law enforcement, the hospital personnel will contact the local law enforcement agency and have them respond to the hospital and interview the victim there. Survivors also have the option to contact law enforcement themselves in a direct manner. This report may happen immediately after an assault, while an assault is in progress, or they also have the option of a delayed report. A delayed report involves waiting to contact law enforcement, and this delay can range from a few days to years after an assault. But regardless, when law enforcement receives that report, they will take it and investigate. Law enforcement may also receive reports from a third party or a witness, and these calls may also come as the assault is happening, after the assault, or it may also be delayed. But as Summer mentioned earlier, it's limited what a law enforcement officer can do when it is made by a witness or a third party, except under certain circumstances, like with children or vulnerable adults. So when a survivor has a witness or a third party make the report, they can't be forced to engage in the criminal investigation. In most cases, a patrol officer is the first responder to meet with a victim before a detective is called to the scene. So next, I'm going to be talking about the responsibilities of law enforcement. And first, we're going to talk about the law enforcement response part of this. So the initial interaction between law enforcement and survivors typically involves identifying the survivor's needs and laying the groundwork for future interactions with survivors. This is a really crucial step because it's a really good opportunity to build rapport and trust with survivors and let them know the next steps and let them decide how they would like to move forward. During these interactions, remember to speak with compassion and create rapport with the victim. The best technique that's recommended is the Forensic Experiential Trauma Interview, or FETI. It focuses on compassionate interviewing, building rapport, and being empathetic to support the survivor and encourage participation in the criminal justice system. If you got to watch our presentation on the neurobiology of trauma, this was discussed there. And if you didn't get to watch it, it is on our YouTube. If a survivor reports to law enforcement prior to receiving forensic medical care, law enforcement should always assess the need for emergency medical care and inform survivors of the SAFE process and how it may aid in a criminal investigation. Any survivor that is interested in receiving a SAFE should have the opportunity to do so, and this includes survivors who provide a delayed report. So even if a survivor waits to report, once they do, law enforcement should offer up medical care. Survivors should have the opportunity to see a healthcare provider, even if evidence may not be collected, and law enforcement is not able to deny a survivor access to a SAFE. As an advocate, you can ensure that forensic medical care is accessible. And again, this should always be the first step because it is always important to make sure that the survivor is safe before we go on to any next steps. So the next priority after addressing safety and any necessary medical care for physical or mental well-being, the next step is to collect information to identify and locate the suspect. Not only is this going to be helpful for the investigation, but it's also really important that they're able to figure out who the suspect is for the survivor's safety and in some cases the community's safety. Law enforcement typically initially seeks the basic information on where the assault occurred, and then from here, they're going to be able to secure the scene and begin examining the area for any additional evidence. It's important to note that law enforcement may ask a survivor if they told anyone about the incident, like a friend or a family member. And this is especially true for delayed reports. And while it is a difficult question sometimes, it's really important because this information can corroborate the survivor's story. So advocates can support survivors by explaining that law enforcement doesn't doubt their report, but they're just looking for some supporting evidence, which could be really helpful in an investigation. And then at this point in the preliminary investigation, responding officers and deputies need to decide whether or not an immediate arrest is necessary. And they typically make this decision based off of factors like probable cause and whether or not an immediate arrest is necessary to protect the community. So next I'm going to talk about the actual responsibilities. Law enforcement agencies' responsibilities lie in three main areas. The first is to protect and support the victim, which I've talked about a lot. The next is to gather preliminary information, and the third is to protect the crime scene so that they can collect evidence related to the case. It is really important that when law enforcement is doing this work, they are being trauma informed, and part of that includes involving victim advocates. Most law enforcement agencies work with the local rape crisis center, who can provide support beyond just the initial stages of the investigation. And law enforcement and advocates can work together to complete other tasks like safety planning, sorting out childcare, finding housing, and other really important steps. Law enforcement can and absolutely should use the local rape crisis center to connect survivors to this type of support. Law enforcement should also be aware that survivors may experience symptoms of trauma that affect their ability to recall information, especially in chronological order. Survivors may also experience a range of emotions, including hyperactivity, flat affect, anxiety, depression, or shock. And these are all normal emotions, and there are no correct emotions for survivors to display after an assault. All investigators should be trained on trauma-informed interviewing techniques, and they should also understand the neurobiology of trauma so that they are able to support the victim and conduct a successful interview. And again, last week we did have our presentation on the neurobiology of trauma, and you can find it on our YouTube channel if you would like to learn more about it. So next I'm going to talk about the actual investigation. And law enforcement is responsible for conducting a thorough criminal investigation. But again, it is important that they also ensure the safety of both the survivor and their support group, which could be someone like a family member or friends. Addressing safety can ensure that a survivor feels comfortable enough to participate in the criminal justice system. And as an advocate, safety is also something that you should be sure to evaluate and address through proper safety planning. Once survivor safety is addressed, investigators should determine if the victim knew the suspect or had any previous contact. It's really important to remember that despite the belief that rapes are perpetrated by strangers, statistics show that approximately 75% of rapes are committed by someone known to the individual. Knowing if the offender is a known individual or stranger is really important in determining the next steps of an investigation. Because if it is a stranger, the survivor may be required to participate in a more detailed interview immediately after the fact because there is a possible threat to the community. But in the case of a known offender, law enforcement may be able to obtain basic information that will allow an investigation to begin, while also giving time to the victim to kind of recover and rest to prepare for a more detailed interview process. Some items that may be important for law enforcement to obtain immediately include questions like, do you know where the suspect is now? How did the suspect leave the scene? Or do you know where the suspect is going? These are all really important questions to figure out the suspect's whereabouts and what to do next. And including details of additional information, such as the use of a weapon or force, threats, or the involvement of drugs and alcohol for DFSA-related cases. Those are all really important to criminal investigations and the prosecution of cases. And then the last part is the forensic analysis of the sexual assault evidence kit, or the SAKE. So they would look at the photographs, they would test DNA samples, and more to further their investigation. As a victim advocate, you may be present for some of these questions, and some of the questions may come across as victim blaming. Sometimes you do have to ask something like, what were you wearing, just to get all of the details of the case. So it's really important that advocates are present with survivors when this is happening so that they are able to provide background and context to avoid re-traumatization and emphasize the fact that it is not the survivor's fault. Next, I'm going to talk about evidence. So Summer touched on this a little bit in her sexual assault forensic exam presentation, but the main piece of evidence we are going to look at is the sexual assault evidence kit, or SAKE. Survivors have the right to a free sexual assault forensic exam up to 15 days after an assault, and it is at this SAFE that a SAKE is collected. Law enforcement agencies store these safe kits along with any other evidence from the crime scene, and these are all things they look into with regard to physical evidence, and they are required to hold these kits for 75 years. Some of this evidence, such as clothing that the survivor is still wearing from the time of the incident or bodily fluids, are collected during the exam by the forensic nurse examiner. And after collection for inclusion in the safe, it's law enforcement's responsibility to obtain this kit from the SAFE program and hold it in the law enforcement agency. It is their responsibility to safeguard the items in accordance with Maryland law and best practice. Other forms of evidence can include things like cell phone communication and social media posts. Obviously, given the environment, like this is something that's becoming more and more common. And of course, this is not the end-all be-all list of types of evidence. It's also important to note that details provided by the survivor, offender, or witness during interviews can guide potential evidence collection. So if someone says the assault took place at a party and there was drinking involved, the law enforcement agency may collect cups from the party to obtain for testing. Next, I'm going to be talking about anonymous reporting. And it's important to note that survivors do not have to report to law enforcement and that they have the right to an anonymous exam. So this means that there's going to be no official police report until the survivor chooses to initiate one. An anonymous kit will be sorted with law enforcement agencies, but there will be no personally identifiable information available on the kit, and it will be held for a minimum of 75 years. In those 75 years, a survivor can come forward and initiate an investigation, and it's at this time that the law enforcement agency would open the kit and gather any important information or details on the assault. Until then, it is simply stored, and after 75 years, it will be destroyed unless someone does open up a case and ask for the time period to be extended. The anonymous option is really important because it allows individuals to obtain a safe without reporting to law enforcement, and it gives them time to process and recover from the assault prior to reporting. They're able to make the decision when they are comfortable if they want to move forward with reporting, and they get to come to the criminal justice system at their own discretion. This type of reporting can keep victims from dropping out of the criminal justice system entirely, which may happen if a victim reports before they are not emotionally ready. As an advocate, it's really important that you discuss how anonymous reporting may affect the criminal investigation. It's important not to make survivors feel like they have to report the assault immediately, but you do want to inform survivors that evidence collection from the scene or even from the offender may be lost if they choose to not report immediately. But remember, this is the survivor's decision, and you should not incorporate your personal opinion, and you should always let them know that it's okay to not report immediately. Encourage them to do what is best for them. So now I'm going to discuss the role of advocates and how they can support survivors while working alongside law enforcement. Your role as an advocate is all about the survivor. If you're involved in the interviewing process, you want to ask what their needs are, you want to inform them of their rights, like having a crime victims' rights attorney and their rights to a kit, and you want to make the relevant referrals. Advocates often provide support and accompaniment to victims during an exam or interview, and they want to check in with their emotional state, provide reassurance or validation, and ask if they need to take a break. When asking about breaks, it's really, really important that you are mindful about snacking, drinking, or bathroom breaks because a survivor should not eat or drink anything if they are still waiting for a safe. Additionally, survivors should try to refrain from using the bathroom before a safe. If they need to use the bathroom, you should talk to an FNE because if they need to go, they can collect a urine sample then. As an advocate, if you aren't sure about something, you can always just ask the FNE or nurse available. Advocating for bathroom breaks and snacks and drinks is much different during an interview process if an exam has already been completed than if an exam hasn't been completed. It's also really important to remember that your silence is okay. Your presence alone may be the only support a victim needs while they process the trauma they experienced. It is also your job to remind the survivors of their rights. While we encourage victims to come forward, we need to remember that under the Violence Against Women Act, no victim is required to speak with law enforcement. Sorry, I just mixed up my slides. And it is also appropriate for advocates to remind victims that they have rights when it comes to SAIC testing, untested kit reviews, and victim notification. It's also your job to provide comfort. During the law enforcement interview, it is appropriate to remind victims that they can take a break or ask questions whenever they want. And keep in mind that although it is best practice for law enforcement to allow an advocate to be present during victim interviews, your local jurisdiction may not permit it. If that's the case, you can always provide information on best practices and agree to not interrupt the survivor or guide their response and story. But if you are still not permitted, you can remain outside the room and be available when needed. Now I'm going to go over some advocate basics. You want to provide emotional support, assist in safety planning, help with other referrals, and always just advocate for the survivor's stated wishes. It is not always about the investigation because it can be about healing and support, and it can really vary from survivor to survivor. A 2006 study found that survivors who had the assistance of an advocate were significantly more likely to have police reports taken and were less likely to be treated negatively by police officers. They also reported less distress after contact with the legal system. So, while advocates certainly strive to protect relationships with other professionals, their role requires them to work on behalf of each victim's stated wishes, and that should always take priority. Now I'm going to touch on things that you want to avoid as an advocate. As an individual, you may have strong feelings about a victim reporting or not, but it's important that you remember to keep any opinions out of conversation as you can directly impact a victim's decision. Survivors may ask for advice, or if you are a survivor, they may ask what you did in their shoes or what you would do, and it is really important to not share your personal decisions or self-disclose because it is about their needs. There is no right or wrong or perfect way of navigating this situation. If a victim asks what you would do in the situation, it's important to know how to answer the question in a manner that highlights the survivor's unique circumstances. If asked something like this, try saying something like, I think it's really important that we focus on your current circumstances. Every individual is different, and although it may seem like it will be helpful to hear what other people have or would do, you need to make sure you are making the best decision for you. It is also not your job to interview the victim. You are not supposed to ask substantive questions or provide information about the sexual assault. You should not interview the victim, but if you do find that the victim is having trouble understanding, it may be appropriate for advocates to provide a prompt by asking law enforcement for further clarity. So asking something like, would you like the officer to explain that again? They should generally be used sparingly and only in situations where they believe there is a risk of serious miscommunication because you really don't want to step on the toes of the investigative process. Next, it's really important that you are honest with each survivor. Promises can lead to false hope, and if they do not pan out, the pain and disappointment can result in survivors refraining from engaging in further support services. It is better to be empathetic and understand that they are going through this and tell them that you believe them and you believe that this happened to them, but refrain from making promises. Keep in mind that not all survivors have the same view of justice, and that view of justice can change over time. Allow each survivor to define the justice they seek, even if that just means time to heal and recognition that they experienced something traumatic, and support them in their attempts to achieve that. Next, I'm going to just go over a summary of everything I've talked about. So recognize that not all survivors will respond to an assault the same. Their emotions and demeanors may vary, and this is all part of the neurobiology of trauma. Remember that not all survivors will want to report the assault to law enforcement. Provide information to each survivor to ensure that they make an informed decision, but do not include your personal opinion. Always, always, always focus on the survivor's needs, especially safety. Support the survivor during the investigative process. If you are permitted to sit in on interviews with law enforcement, Be sure to advocate for the survivor's needs and prompt investigators to provide clarity if the survivor is struggling with a question. You do not want to speak for the survivor. This can affect an investigation and potential prosecution or conviction. And again, it is about the survivor and we want them to tell their story. Know your agency services and local resources. You need to be prepared to make local referrals. And also, it is important that you know your confidentiality requirements and protect each survivor's personally identifiable information and care plans. Even if a survivor is participating in the criminal justice system, remember that your confidentiality agreements are. Keep the survivor information private and secure. Law enforcement may want information provided to you, but without survivor consent, you must maintain confidentiality as required by your discipline and funding avenues. That concludes my presentation. So if you have any questions, you can put them in the chat or email me and I will hand it over to Lindsay.
Can you see my screen, Alyssa?
Yes, it just needs to be in presenter view. Then we're ready to go.
One moment for me.
Perfect. Now it's in presenter view.
Great, thank you. All right. Good morning, everyone. My name is Lindsay O'Neill, and I am a senior staff attorney at MCASA's Sexual Assault Legal Institute. I am also the Sexual Assault Kit Initiative project attorney, and in that role, I provide legal services to survivors impacted by the backlog and untested and unsubmitted sexual assault evidence kits in Maryland, and training and technical assistance on sexual assault evidence kits and crime victims' rights to other professionals working with survivors. Today, I am presenting on the role of the prosecutor in the sexual assault response team. So first of all, who are prosecutors? Prosecutors are attorneys who represent the whole state or country, not an individual survivor. Since prosecutors do not represent survivors, there is no confidentiality and there is no attorney-client privilege. In fact, prosecutors have ethical obligations under the United States Constitution and state law that require them to turn certain information over to defense and to the courts. Since prosecutors represent the state or the country and not the survivor, at times their interests can conflict with that of the survivors. In Maryland, prosecutors' offices are called state's attorney's offices. They may be called something different in other states, such as district attorney's offices and federally United States attorney's offices. There is one state's attorney in every Maryland jurisdiction, meaning every county and Baltimore City, and that person is elected into that position. The lawyers who go to court on behalf of the state are called assistant state's attorneys. Prosecutors run criminal cases for the state. They decide if someone gets charged, what crimes get charged, whether to offer a plea bargain or go to trial, and what plea bargain to offer. They also decide what evidence to put on at trial and what sentence they will argue for after a conviction. As advocates, you all can help survivors understand the role of the prosecutor because it's not always apparent and the state doesn't always explain that to the survivor. One of the primary responsibilities of the prosecutor in the criminal justice system is to decide who gets charged with a crime and what crimes to charge. It's up to the state's attorney's office because they have something called prosecutorial discretion. A famous quote from a United States Supreme Court case reads, "So long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in the prosecutor's discretion. Once a decision on whether or not to prosecute has been made, it's generally final and difficult to change. It's important for advocates to explain to a survivor why a case may not have been charged. A survivor may think that the prosecutor didn't believe them or that they wouldn't make a good witness, but typically that's not the case. Oftentimes, a state's attorney's office declines to charge because they don't think there's enough evidence to prove the case beyond a reasonable doubt, which is their burden of proof in criminal court. This is especially true in cases of sexual assault, where due to the nature of the crime, there may be little evidence or few to no witnesses. So how do prosecutors determine what crimes to charge and who? First of all, they need to assess the facts of the case or the conduct alleged to determine what crime or crimes occurred. They then will evaluate any evidence, which, as I just mentioned, can be difficult in sexual assault cases. Typically, there aren't any witnesses, and the evidence may simply just be the survivor's word against the perpetrators. Prosecutors also have to consider ethically, by law, whether there is probable cause to charge. In other words, whether there is sufficient reason to believe the crime occurred and the person charged is the person who committed the crime. Prosecutors don't have to believe that there is sufficient evidence to prove a case beyond a reasonable doubt in order to be able to charge a case. But most prosecutors will consider that in their decision because it is the burden of proof if the case goes to trial, and they don't want to put a survivor through the criminal justice process if they think there's a high chance that they will lose. Prosecutors can also take into consideration various objectives when deciding whether or not to charge someone with a crime. For example, they can consider justice for a survivor, rehabilitation or punishment of an offender, or protection for the community. Now, I just alluded to there being a difference between probable cause and beyond a reasonable doubt. Probable cause, again, is sufficient reason based upon known facts to believe a crime has been committed or that certain property is connected with a crime. This also includes probable cause to believe that the particular person being charged is the person who committed the crime. Now, in many cases, the survivor will know the perpetrator and identity will not be a problem. But this could be an issue, for example, in a case where the perpetrator is a stranger. If the case goes to trial, as part of jury instructions, jurors are told that they can only find the defendant guilty if they are convinced beyond a reasonable doubt of their guilt. This is the burden of proof that's applied to the state at trial. And that is the burden regardless of whether it's a jury trial or a trial in front of a judge, known as a bench trial. Now let's dig a little bit deeper in how prosecutors decide what crime to charge. Prosecutors need to look at the conduct alleged or the facts of the case to see if they satisfy all of the elements of a particular crime or crimes. The elements of the crime are the parts of the crime that must be proven beyond a reasonable doubt in order to sustain a conviction. Not all bad behavior is a crime under Maryland law. Additionally, one act may in fact lead to multiple charges. For example, anything that can be charged as rape can also be charged as sex offense in the 4th degree, which is an unwanted sexual touching. It can also be charged as an assault in the 2nd degree, which is an unwanted offensive touching generally. Prosecutors must also consider whether the alleged conduct makes out a felony or a misdemeanor. Felonies are higher level crimes. Misdemeanors are lower level crimes. In Maryland, many misdemeanors have statute of limitations. Felonies do not. That means that a felony can be charged sometimes decades later after the crime occurred. Misdemeanors, on the other hand, typically must be charged shortly after the crime occurred, absent a few exceptions. Otherwise, they cannot later be charged. I think it's helpful to look at an example. This is an excerpt from the Maryland Law on Harassment. Under Maryland Criminal Law, Section 3-803, harassment is defined as following another individual in or around a public place or maliciously engaging in repeated behavior that seriously annoys or alarms another individual with 1, the intent to harass, alarm, or annoy another, 2, after receiving a reasonable warning or request to stop by or on behalf of the other, and 3, without a legal purpose. There is also an important exception. This section does not apply to a peaceable activity intended to express a political view or provide information to others. This legal definition is quite different than our normative definition of harassment. What we may think is a crime in a colloquial sense may not always match the actual criminal law. So when prosecutors, for example, are looking at whether or not they can charge harassment, they have to consider whether there is some type of legal purpose for the conduct. In some cases, the survivor and the perpetrator may have children in common. The perpetrator might argue that the 200 emails that they sent were in regards to the children. Depending on what type of custody or final protective order might be in place, that might actually prevent a prosecutor from moving forward on a harassment charge because there was a legal purpose. Another important question that sometimes prevents prosecutors from being able to charge a crime like harassment is whether the perpetrator kept doing these things after they were asked to stop. There also does have to be a reasonable warning or request to stop. If the survivor never told the perpetrator to stop, the judge can't find that legal harassment has occurred. So this goes back to managing survivor expectations and explaining that just because a particular crime can't be charged, it doesn't mean that a prosecutor's office thinks that what happened was okay or that they don't believe the survivor. What it typically means is that a technical part of the law just simply did not occur. So as I mentioned earlier, prosecutors also must evaluate evidence when determining whether or not to charge a case. They can consider admissible evidence, which is evidence that can come into a court case. They can also consider inadmissible evidence because that evidence might ultimately lead to something admissible. Examples of inadmissible evidence include hearsay. That's when someone says that someone else told them something. For example, Jane Doe testifies that Mary told her that John was at the party. In court, a judge or jury can't consider that testimony, but prosecutors can in their investigation because they can go and talk to Mary. Similarly, rumors can't be brought up in court, but a prosecutor can investigate those rumors and talk to the people who are spreading them. Examples of admissible evidence that can be considered by both prosecutors and the court include photos, perhaps of injuries, or in a drug-facilitated sexual assault case, perhaps there's a photo of the victim passed out at a party that can corroborate their testimony that they were unable to consent to what happened to them. Written statements can also be considered. They do need to meet certain requirements in order to come into court so that they are not hearsay. But for example, if a defendant wrote a statement apologizing, that would potentially be admissible in court. some 911 calls, police testimony about what they observed, what actions were taken, and any statements made by the defendant, medical records, other physical evidence, clothing, broken property, perhaps DNA evidence collected during a sexual assault forensic exam, electronic evidence, which can include text messages and voicemails, also location services, and then also jail calls and mail. So far, I've talked a lot about the burden of proof at trial. The reality is that most criminal cases never go to trial, and that's because the defendant accepts something called a plea bargain. A plea bargain is where the defendant may plead guilty to a lesser offense, which can be one of many charges. Remember how I said earlier, one act could lead to multiple charges. So they might plead guilty to the lesser of those offenses, or perhaps to a top charge, but to a lesser sentence, all to avoid that risk of going to trial. Some pros of plea bargains for survivors is that for some survivors, it will save them from having to testify, which again, for some survivors can be a good thing. Testifying can be incredibly invasive. Talking about some of the most intimate details of your life in front of a bunch of strangers. It can also be re-traumatizing, having to recount the details of what happened. And cross-examination can also be particularly difficult because generally speaking, defense attorneys will try to get a rise out of the victim. Now, that's not to say that all survivors don't want to testify. Some survivors do find testifying at trial to be incredibly empowering. Some cons to plea bargains for victims include the fact that a survivor may not get their day in court. Additionally, they might not agree with the offer. They may feel that the offer presented does not account for what they experienced or the severity of what they endured. An example of this would be a plea to second-degree assault in a rape case. Second-degree assault does not account for the sexual nature of the crime, and it also does not require sex offender registry. Another possibility short of trial is where the prosecutor drops the charges. This is also known as nolle prosequi. Sometimes prosecutors will evaluate the evidence a little bit more closely, and they'll determine that there just isn't enough evidence to prove the case beyond a reasonable doubt. Additionally, sometimes new exonerating evidence will come to light. That doesn't necessarily mean that a survivor lied. It just means that the state would have much more difficulty proving that the defendant committed the crime. Another big one is witnesses who are no longer available or cooperating. Could also be that the witness cannot be located or perhaps they're deceased. As of October 1st, 2023, a prosecutor is legally required to explain to a survivor why they are not bringing charges. That's if the survivor requests that information. They can receive this information in an in-person meeting, virtually, by phone, or in an email. It really depends on the survivor's personal preferences. Now, if a case does go to trial, jury trials typically begin with something called voir dire, or jury selection. It's up to the defendant to decide if they want a trial by jury or a trial by a judge, called a bench trial. Next, there will be opening statements by both parties, the defense and the state. Then it's the prosecution's case. The state goes first because they have the burden. Prosecution case can include direct and cross-examination of the victim witness and any other witnesses that will help support the case. Following that, a defense attorney, as a matter of course, will make a motion for a judgment of acquittal. They will argue to the court that what was presented by prosecution was in some way legally insufficient. As advocates, it's important to make sure that a survivor knows that this is normal and to be expected, especially if the survivor is watching the trial. Now, if that fails, defense can put on their case if they want to. They're not required to do so, and a defendant doesn't have to testify, and their silence cannot be held against them. Defendants can, however, call other witnesses to testify for their case. After that, the state can put on a rebuttal case if appropriate. For example, the state can present evidence or witnesses that contradict the defendant's alibi. Following any rebuttal case, there will be closing statements by both parties. Then there will be deliberations and a verdict. Jury instructions are given at the beginning and end of trial so that jurors know what they need to be deliberating on and how they should render a verdict. Verdicts can happen fairly quickly, or they can take a while. If jurors cannot agree on a unanimous verdict of guilty or not guilty, it is a hung jury. The judge in that case can give an instruction to help jurors reach a resolution. If not, the case will result in a mistrial, and the state will have an opportunity to try again, reach a plea bargain, or dismiss. And generally speaking, prosecutors do take the survivor's wishes into consideration when making that decision. If the defendant is convicted, either by a plea bargain or a trial, there will be a sentencing hearing where the judge decides and delivers the punishment. In Maryland, judges are required to consider sentencing guidelines for what would be an appropriate punishment based on certain characteristics about the defendant and the crime. Judges in Maryland do, however, have discretion to go above or below the guidelines, so long as they put that reasoning on the record. Each party will also have an opportunity to tell the court what they think the punishment will be. Victims also have a statutory right to be heard, and they can do so by addressing the court through a victim impact statement. The court must consider the victim impact statement when making their decision. Advocates can help victims with the victim impact statement by giving them general information, by providing them information on what to say and how to say it. They can also deliver the statement to the court on the victim's behalf if the victim does not wish to read the statement themselves. Most importantly, however, the victim impact statement does need to be in the words of the survivor. As a final note, a prosecutor's interactions with a survivor throughout the criminal justice process can tend to vary case by case. Some interactions are directly with the prosecutor, and others are with the victim witness coordinator, who works for the state's attorney's office and is usually a social worker. Some interactions can include an initial interview or screening interview, where the prosecutor is deciding what to charge. Interactions can also include informing the survivor about the status of the case and any plea bargains. Preparation for trial, including preparation for direct and cross-examination. As a reminder, prosecutors are not confidential. There is no attorney-client privilege. Prosecutors do have obligations to tell information to defense and the court, depending on what that information is. It can be incredibly helpful for survivors to have both an advocate and a crime victims' rights attorney throughout the criminal justice process to help that survivor ensure that their voice is being heard. They can help to assert the survivor's rights and also enforce them when necessary. So that concludes my presentation on the role of the prosecutor in the sexual assault response team. Thank you all for your time and attention this morning. As a reminder for those of you who don't know, the Sexual Assault Legal Institute does provide crime victims' rights representation to survivors in criminal cases. If you'd like to refer a survivor for our services, you can provide them with the Sexual Assault Legal Institute phone number, which I've included on the slide. Additionally, if any of you ever have any questions, you can always send me an email. I've also included my personal work email on the slide as well.
Great, thank you so much for that, Lindsay. It was a wonderful presentation. So now we're going to watch a SART panel, and the panelists will discuss their different roles on the SART team. Due to scheduling conflicts this time, we will be watching a SART panel from our most recent sexual assault victim advocate training. This occurred in September 2024, and it will be facilitated by one of our former Safe SART policy advocates. So Cameron's going to pull up the video. If you have any questions during the video as you're watching it, please put that in the chat. And we will do our best to get to your questions during the training today. And anything that's unanswered, I will send to our trainers for follow-up. So I'm going to turn it over to Cameron.
Okay, Alyssa, can you see the video?
Yes.
Okay. And then if you guys can just put like a thumbs up in the chat, just so I know the audio is working, that would be great.
Of the presentation, we will hear directly from those who have the roles we just discussed. So it'll include a rape crisis center advocate, a law enforcement officer, a forensic nurse examiner, and a prosecutor. These individuals that we have with us today work on different sexual assault response teams throughout the state to help pursue this interdisciplinary and victim-centered response we talked about earlier today. I'm just going to begin with some introductions of our panelists, and then we will get into questions. If you have any questions outside of the ones that we have set for today for the panelists, feel free to drop them in the chat. I'll kind of be semi-monitoring it, so I might miss things and will interrupt as needed to kind of address any questions that come up. But if we don't get to any questions dropped in the chat, I will be sure to forward them to the panelists so we can get an answer to your question. All right, so as I said before we begin, I just want to give a brief introduction from each of our panelists. So this panel includes, for the role of the Rape Crisis Center advocate, we have Shemaine Jones. She has been the sexual assault program manager for the Southern Maryland Center for Family Advocacy since 2018. She has been with the agency for 8 years, first as the district court advocate, which led to her creating the case management program in 2017. She earned a Bachelor of Science degree in Child and Adolescent Studies and a minor in psychology from Bowie State University. And she is now less than 8 months away from earning her Master of Social Work degree, with one concentration in trauma and the other concentration in child and family. So thank you so much for being with us today. Next up for the role of the FNE, we have Stacy. So Stacy is the forensic nurse examiner for the University of Maryland Upper Chesapeake Health in Harford County, Maryland. She has been an emergency department nurse since 2008 and a forensic nurse examiner since 2018. She recently transitioned the forensic program to the Aberdeen Medical Center campus, which was recently opened in February 2024. So thank you, Stacy. We're super excited to have you today as well. Next up for the role of the prosecutor from the state's attorney's office, we have Mary Murphy. Mary is the chief of the Special Victims Unit in the Howard County State's Attorney's Office, where she has been a prosecutor for over 33 years. Ms. Murphy has primarily handled child abuse, sex offense, and domestic violence cases in her many years as a prosecutor. She has held leadership positions on the Maryland State Bar Association, including chair of both criminal law and litigation sections. Additionally, she has served on the Maryland Criminal Pattern Jury Instructions Committee. She also served on the board of directors for the Kidney Foundation of Maryland and the Trinity School. So thank you so much, Mary, for being with us today as well. And finally, for the role of the law enforcement officer, we have Jason Baum. So Jason has been a police officer for 30 years. He worked for the city of Pittsburgh Police from 1994 to 2004 and was a team leader and lead sniper for the SWAT team. In 2004, he left the Pittsburgh Police Department and joined the Montgomery County Police Department, and he was promoted to Detective Corporal in 2013 and joined the Special Victims Unit Division in Domestic Violence in 2015. He was promoted to Detective Sergeant and took over as supervisor of the Special Victims Investigation Division Sexual Assault Unit. So thank you so much, Jason, for being with us today as well. Just to give a rundown of how questions will go, I'm going to start with a general question for each of us. So for organization purposes, I will start with Stacy, I'll go to Mary, and then we'll go to Jason. Shemaine, some of your questions are more specific to advocate work. So when we get to you, I'll give you your question in a way that it's phrased so it's applicable to the work that you do. If you need any clarification or me to repeat any questions, just let me know. I'm happy to. And thank you so much to all of you again for being here today. We appreciate your time. So to start off, the first question is, what is it important for a victim advocate to know about your role in the sexual assault response process? So Stacy, we will start with you.
I don't think we can hear her. I don't know if anyone else is having the problem.
Yeah, I was wondering if that was just me. Okay, sounds good.
Can you hear me now?
Yeah.
Okay, sorry, I had to change my microphone here. I think what patients typically experience with nursing, especially when you're in a hospital setting, is that your nurse forms a relationship with you, they care deeply about you. There's a rapport that's built in healthcare. And this role is a little different in that you don't want to make too much of that relationship with the patient. So we really lean on our advocates to make that relationship because we don't want our exam to be biased. We don't want any part of the evidence collection or the statement or any interview portion of our exam to be biased in any way. So unlike every other aspect of nursing, we try not to make that very close connection with them because I don't want to maybe see something that's not there or, I don't know, enhance my exam in any way. So we really lean on the advocate to make that connection with the patient. And we're there to do a job. I collect a statement, I collect evidence, I take photographs, I get you where you need to go. So I think from a nursing perspective, that can be a little different, but it's purposeful to protect ourselves and the patients later in the litigation process.
Thanks, Steve. So Mary, I will hand it over to you.
So our role comes into play typically when, sorry, can you hear me? Okay. When the case gets charged or is being investigated, depending on the nature of the alleged crime. We too have to maintain some distance in terms of trying to be professional and non-biased and non-judgmental when we're going into the case. So we do rely as well on our advocates, and we have in-house advocates that transition typically with the advocate from the hospital setting. And we rely on the advocates to provide resources so that the victim will stay on board and get help as they go through the process. We typically will meet with the victim after the investigation has been completed to determine whether or not to go forward. And depending on the type of case, sometimes we meet with them before we charge to talk about the facts of the case, and especially if the victim has been reluctant to go forward, either by starting the process as a Jane Doe or coming forward later or having second thoughts about the case. Then we'll meet with them to talk to them about the process, because we think it's really important for them to understand the process, because they are the ones that would have to testify and go forward. We find that by meeting early with them, then their questions are answered and they are able to proceed on a much higher basis, percentage basis. Our process is that we try to rely on the advocates to provide the support as we're going through the trial prep process and the trial process, so that there's one person that they can talk to, not about the facts, but about their feelings, about everything else. And we're the ones that they discuss the facts with and prep the case for trial. We try to explain the process to them and what questions they will be asked. And we also prepare them for questions that the defense might ask of them at trial, so that they're not walking into a courtroom not knowing what may be expected of them in terms of the questions, and they're not going to be surprised by a defense attorney by questions that they might ask. We also provide courtroom tours to tell them and show them where they'll sit, make them as comfortable as possible prior to going into the courtroom. Prior to any plea negotiation or discussion, we always try to meet with the victim and to explain to them the guidelines, to explain to them the strengths and the weaknesses of the case, and to get their input about a possible plea. Ultimately, I think it's important that we make it clear to the victims that we have to make the decision in terms of what's an appropriate plea offer, and to explain to them, that we want their input, we want to know what their goals and expectations are and what they would ultimately like to see happen. But we try to also make it clear to them that that burden is not on their shoulders, it's on the state's shoulders, as we are the ones who have to bring the prosecution. That's sort of, and then we, of course, go into the courtroom and present the evidence, and work with the forensic nurse examiners to prep them for trial and to put them on, as well as the investigators in the case. And we go over the evidence with them and put the trial together and all the evidence. So that's sort of a nutshell of what we do.
Thank you so much. Jason, I will hand it over to you. So what is important for a victim advocate to know about your role in the sexual assault response process?
Yes, so we, in most circumstances, have the most contact with the victim throughout the entire process. Depending on the victim's wishes, is kind of determined on how much contact we have with the advocates. There are some victims that, want to deal with us directly, speak with us directly, have all the information and the updates in their case come from us directly to them. And there's some times that they want us to interact with their advocate, who will then provide the information to the victim. So it's kind of determined solely based on the victim's wishes. There are times, obviously, these cases are very traumatic for the victims, and throughout our investigation and while we're collecting information and evidence, we may have to do follow-up interviews and have clarification questions with the victim. Sometimes those questions can be difficult conversations. So when we do have those types of conversations, which could be upsetting with the victim, or if we're unable to, move forward with, an arrest in a case, which does happen, those outcomes can be, very upsetting to the victim. So we make sure throughout the process that they are engaged with their advocates, that they do have advocacy contacts, And if they don't, we make sure that they get those resources. But then once we keep all of our victims updated throughout the entire process. We're open with them in the beginning that obviously we can't make any promises as to the outcome of the investigation, and that sometimes depending upon the complexity of the case, our investigations could take months, if not longer, depending on what's needed throughout the investigation. But throughout that entire time, we stay in contact with the victims. We make sure that they have constant updates on where we are, where we stand within the investigative process.
Great, thank you so much. So Shemaine, my question for you is, how do you explain your role as an advocate to others in the response process or to the survivor?
So when I explain my role as an advocate, I usually start by letting everyone know that we are specifically here to support the survivor. Whatever the survivor needs, whatever resources they need, whether it's in-person support, whether it's court support, whatever it may be, we're here to support them. We also, more importantly, we educate the survivors and anyone that we come into contact with about our role. And like, again, I said, about supporting the survivor. We do act as a liaison for the survivor between whether it's the sheriff's department, the state's attorney's office, their advocates. But like I said, most importantly, we're here to support the survivor in whatever it is that they're concerned about. Like Jason said, sometimes they want to speak directly with an advocate or have an advocate present when they're meeting with law enforcement or the survivor. So again, whether it's for a protective order, the temporary, the final, if they want us there, we're going to be there to support and offer resources.
Great, thank you so much for sharing. So moving on to our second question, how do you work with victim advocates throughout the sexual assault response process? So this can include before, during, or after an exam, or during interviews, or any other sort of time you can think of. So Stacy, we will begin with you.
Sure. I think we have maybe the most intimate relationship with the victim advocate as a forensic nurse. We in Harper County at least have a very tight partnership. So I usually engage the advocate before I even go to the hospital and have them come in with me at the same time so that they can start to build that rapport with the patient before we even do the exam. The relationship used to be we would offer an advocate if the patient wanted it or not. We have now moved to a model where we call the advocate every single time. It's not it's a 100% service. So anyway, I would say that I usually give them some kind of report about the patient. I think most of our forensic programs are happening in an emergency department setting. Most of our hospitals or hospital settings that we're doing this. So for a safety perspective, I do like to make sure that the advocate feels safe. There's a lot going on. Sometimes there's mental health issues with these patients. Sometimes there's substance issues with these patients, depending on the case, and everyone is different. There's family issues, a lot going on in this period of crisis right here in the beginning. Usually law enforcement's involved, or not at that point, but I would say we get to the hospital at the same time. We kind of figure out what's going on. I usually have the advocate in the room before I even go, start the exam process. We're getting the room ready. I'm kind of starting to get consent and all this information, and the advocate's really building that relationship. So they're giving me crucial information before the exam even starts, like, hey, I think we have some social issue here, or hey, I think we have X, Y, Z. We're really partnering and starting to think about discharge planning, because the exam takes about an hour, maybe an hour and a half, and then the other 3 or 4 hours after that is all evidence, procurement or whatever, we're packaging things up. That actually takes longer. All the paperwork part, the exam itself doesn't take very long. So we have a very short window of time together. So we're partnering with each other for information sharing. I always use them in lieu of any family member unless the patient requests it to do the exam with me. So our advocate is in the room probably 99% of the time now. So they can help witness my exam so I'm not alone with the patient. And also it limits the patient feeling uncomfortable about saying some really intense things in front of their family. We have a questionnaire that we use. I think that maybe 5 or 6 programs use the same questionnaire now, but it is very detailed questions. And so you want somebody in that room that's unbiased, not a family member. You're not saying things that you've had to do, which can be embarrassing sometimes, I think, for patients or make them feel shameful and things like that. So anyway, it's nice to have a trained individual in there. So we prep before, we do the exam together, and then usually I kind of leave the advocate with the patient after the exam because I'm over here packing evidence up, and they're really now taking over and doing that discharge plan. Do they have some safe place to go? Are there financial issues? You know, whatever it is, and they kind of really take over from there. I'll come back in and loop in later for medications, their medical portion of the discharge, but the advocate's really kind of taking over emotionally and post-discharge planning from there. If there's any questions later, I'll usually touch base with the advocate. Hey, is there anything that I missed? Or, you know, we kind of debrief afterwards. Is there anything that you think I could have done better? We help each other professionally develop as well. Hopefully that answers that.
Thank you so much for sharing, Stacey. So Mary, I will pass it over to you.
Sure. In our jurisdiction, a lot of times we don't have the immediate access to the advocate who responds to the hospital. Typically that happens when we're not present and involved in the process. Where we would have the contact typically with the SAFE advocate would be if there is a passover from the advocacy being performed for the victim to the prosecution process and the investigative process as it's a decision-making process of going forward. As Jason indicated, sometimes these cases are more complicated and do require a lot more investigation, particularly if we're waiting on a DNA analysis. Our jurisdiction sends it out to outside lab, so it takes typically 2 months to get the results on a rush, which is tough sometimes. But that transition occurs, and our advocate in our office then will set up meetings and assist in getting resources along with the hospital advocate. So it's a transition type of a communication, I think, and that happens between the advocates and our office. And occasionally we'll have the direct contact with the hospital advocate, but then once our advocate gets that baton passed to them, they work very closely with the victim to make sure that the resources are there and to be the conduit for the communication, whether it be for the outcome of the results, those types of things, and waiting for the decision on the prosecution, and then scheduling all of the meetings and giving the updates on the process for the court.
Great, thank you so much for sharing. So Jason, we'll go to you.
Yeah, so it used to be here that it was law enforcement's responsibility to contact the advocates when we were notified that there was a victim at a hospital getting an exam. Like Stacey was saying, that's changed now. We primarily use Shady Grove Hospital, and the advocates are now called directly by the forensic nurse examiners at Shady Grove. Also, when I get the reports, I assign the cases out to the detectives. My case assignments and the police reports also get sent to our victim advocates, just as a fail safe to make sure that our advocates are notified that we have a victim, and then they get our case assignments and they reach out to make sure that victim was connected with an advocate and they have the resources that they need. We generally don't have at least in the beginning of the process, a lot of contact with the advocates. There may be times where, you know, our paths cross at the hospital. We'll introduce ourselves, you know, and speak to the advocate or you know, to see if they have any concerns or anything that we know about before we go in and meet with the victim. We try to keep the advocates out of the investigative process so they don't become witnesses in our case. So we try to do our interviews without having the advocate in the room. But again, it's dependent upon the victim. We do sometimes have cases, it's not very often, but we do sometimes have cases where the victim really wants an advocate in the room with them. And in those cases, it's more important for us, for the victim to feel comfortable and feel open to speaking with us. So in those cases, we'll obviously bring the victim in, but we do try to keep that aspect of it separate and then just communicate with the advocate and, provide them with any information that they may need in order to better support the victim. But again, this is all determined upon the needs of the victim, and that's what's most important for us throughout the whole process.
Thank you so much. So Shemaine, my question for you is, can you tell us a little bit about your work with victims and other professions before, during, or after a sexual assault forensic exam?
So we have two ways that we're contacted through our crisis line, but I can't say two ways, but we might, and most often we're contacted through the emergency room, the forensic nurse or whoever's on call that night. They will call our crisis line, give us a little bit of background information, and we'll all meet at the hospital for the exam. Sometimes the exam has to be scheduled for a little bit later in the day if we don't have a nurse on call at the moment or at the hospital to complete the exam. Other times we're contacted directly through law enforcement after they have gotten the case and kind of been made aware of what's going on. I prefer to get the call and go straight to the hospital. I actually responded to 2 this morning, so I am beyond exhausted right now. And they were both pretty, I can't say difficult, but they were both under the influence. So we had to wait a little bit, kind of wait until they sobered up some, and then we could continue the process. So I still have somebody at the hospital right now that we're working with. But for the most part, I halfway forgot the question. I have it here, so let me get back to it. So like I said, that's how we're contacted before. During the exam, we're there. We're there to let them know that whatever they need, we're gonna, let me go back to my notes. I'm all over the place right now. So like I said, we're there to advocate for them. We're there to act as a liaison. We're providing accompaniment. We interact with whatever agency we need to. So whether that's the ER staff, if there needs to be sheltered after the incident, after they're done at the hospital, providing transportation. Honestly, it's just whatever they might need. So like case management that day, whether it's case management 2 weeks from that day, accompaniment to social services. We even go, if they need to apply for services anywhere, we're normally there to support them, kind of walk them through the process, whether it's applying for victims' compensation, you name it. So, sometimes I work with the client from that very day until about 6 months later. So even if the case extends or the trial extends to a year later, which we've had happen before, we're there the entire time. Even with law enforcement, even with the state's attorney's office, here in Southern Maryland, we're kind of just now getting advocates in the state's attorney's office. So we can pass the baton to them. Usually because we've built such a close relationship with the survivor, they prefer to still have us involved. So it's whatever they need. We're always going to be there. Sometimes I try to say, here, it's okay. You can go ahead and talk to this person. I trust them. But again, if they want us there, and I run this program by myself, so it's usually just me by myself handling every single client that comes through the program. The relationship that we have with law enforcement, I agree with Jason. I prefer to not be in the room for the interviews, but there has been one instance and it was okay, but of course, like I don't want to be called in to testify for anything, you know. So it happened to work out. The case did go to trial. The offender was found guilty, and we kind of just helped her move forward from there. Therapy is always offered free of cost. Obviously, nothing. We don't charge for anything, whether it's a cell phone, you name it, we're going to provide it. Financial support afterwards if they're in a bad situation. So and then out in the community, we're always doing outreach, educating our departments, whether it's individuals from the college, the local colleges, whatever they're, even our local base, we do outreach and prevention there as well. And then we work with those clients who are not active military, but things have happened where they've been assaulted by a military member, which I'm not even going to get into that. That's a whole different situation, but that's the gist of it for me.
Thank you so much for sharing all of that. Okay, so moving on to our next question. What should a victim advocate be able to explain to a survivor about your role in the sexual assault response process? So some things that you could touch on are things like confidentiality, number of times victims are typically interviewed, or things relating to mandated reporting. So Stacey, we'll start with you.
Okay. I think when I get to speak to the patient, I'm going over what the exam entails. They can take that in, but all the other details, because there's so many and they're kind of in crisis mode when we're with them, I think it's hard to take in. So we really rely on our advocates to kind of go over some of the other information, such as this is a confidential service that you will not get a bill for this in the mail. This is a free service. Some of those things come up like, oh, am I, especially for minors, are my parents going to get a bill in the mail about this? Things that they're worried about reporting because they are worried about the downstream. So it's really important for them to, our advocates, to kind of reiterate some of those things because they're not taking that in when I'm talking to them. They're worried about what's going to happen in this next hour or so in this room. So I think it's really important to explain, the confidentiality, the free service, some of the mandated reporting situation. Obviously, if you're 13 or older, just knowing that information to be able to answer some of those questions. If you're 13 and older, you can come in and have these services confidentially, unless it is a caregiver that is involved. Then we do have a duty to report. But other than a caregiver involvement, if I'm 13 and I met a friend and this happened, again, that's their choice whether they want to report or not. So I think just knowing some of those things and being able to answer some of those questions before we get in there is really important. And then I think a lot of patients are anxious about the process itself. So just understanding what is a forensic exam, what is going to happen, and that will come with experience and time. But I think being able to answer some of those questions for patients and just saying, you're going to have this exam, but you're allowed to refuse any portion of the exam. It is your exam to have. So if there's something you don't want to do or aren't comfortable with, you don't have to. This is that, just reiterating with the patient is the driver is really important from my perspective. And I'll let Mary take over from there.
So from my perspective, I guess the advocates would benefit by knowing and hearing what the process is. And typically, in each jurisdiction, they'll handle it differently. So whatever jurisdiction you're in, become familiar with how their process works. Typically in our jurisdiction, we work very closely with the law enforcement, and if it's going to be an on-scene arrest based on the exigency or the facts of the case, then we're going to have a much sooner contact with the victim than we would if it were a case where there was an exam and then there was going to be an extensive examination. But at some point there will be a review of the case and determination, if it's not an on-scene arrest, whether or not charges would be brought. And regardless of whether we bring charges or not bring charges, we always offer the victim a meeting regarding that decision. what we typically do in our jurisdiction is to bring in the victim after charges have been filed and it goes to the grand jury, and have what's known as a meet and greet meeting, where we simply meet with the victim, have that contact, and make sure that they understand what the process is that will go forward from the charging, the different court dates that they will get notification of, what they'll be needed to come to, what they don't, and not get into the facts of the case the first time that we meet, because we're trying to build that rapport that the advocate probably already has, but that here's yet one more person. And before we do an interview with the victim to go over the facts, typically we've looked at the body-worn camera, the recorded interview that's already occurred. So, we'll have all that information, and they can be assured that we will have reviewed all of that before we meet with them, so that they don't have to, in that first meeting, go into any details other than, to get to know them, to see how they are doing in the process, and to gauge whether they need additional resources, and talk to them about what resources might be needed and what we can do to help. Then, that they will be prepped by the prosecutor to go to court, and that they will be prepared for both the questions that they will be asked and the questions by the state, but also questions that they would be asked by the defense, so that they're not going in cold to the courtroom. And that the prosecutors will describe what the process will be like, how long the process can be anticipated, because that can depend on the type of case that it is, and how many days it would be, and explaining to them that they're not going to be there testifying for 5 days, that their piece is discreet, and that we will include them in decision making, and try to come to a decision as what's best for them, number one. And I think that's the most important thing for the advocates to know about our role. Jason?
Yeah, so there's a couple of things, actually. So it's important for the victims to know that just because they file a police report and we begin an investigation doesn't mean that we're then going to force them to continue and move forward with this investigation. A victim at any time can make a decision that they want to stop the investigation or pause the investigation because they're feeling uncomfortable with it. And that's completely okay with us. If they contact us and say, hey, I don't want to go forward, we stop right there. We don't move forward with anything. And then they're free to contact us again at any time when they feel more comfortable or they feel ready to continue the investigation. And then we'll pick up where we left off. There isn't a statute of limitations for our cases. So if they want to stop and they contact us, a year later, 5 years later, we pick up right where we left off and continue on. It's important for the victims to know the reality of these investigations. We get a lot of victims that will contact us, a day after we get the report, 2 days after we get the report, and want updates on their cases, and has an arrest been made yet. And the reality is that, it just in Montgomery County, we get on average 280 cases per year. And I currently have 2 detectives and myself. So the reality is that at any given time, each one of my detectives has, 14, 15 active cases that they're working. So updates where they would expect, or the time frame that they would expect to have updates, might not match the reality of what we're able to do, because we have so many active cases that we are currently working. So these cases can take, a lengthy amount of time. And then when you're talking about DNA, if we don't make an arrest on a case, and we're waiting for DNA to come back because we need that part of the evidence to give us the probable cause in the case, that could take upwards of 6 to 8 months just because of the backlog right now. We always maintain the victims' anonymity. We do not put our victims' names in any search warrants. We don't put their names in any arrest documents. So none of those things, or that, outside entities can get a hold of, would have the victim's information in it. We simply identify them as victim A. When we speak to the suspects in the case, that's where, unfortunately, the victim's identity can't be kept anonymous, because, we have to establish the fact that the victim and our suspect were in the same place, were engaged in this conduct. So the suspect is going to know what this case is about when we get to that step where we interview them. But again, we take every step that we can to maintain their anonymity from any outside people that are not involved in the investigation. And then throughout the process, of course, if anything comes up where they start to feel unsafe, we ask that they contact 911 first, but they relay all that information to us so that we can take steps to ensure their safety throughout the investigation as well.
Thank you so much. So Shameen, my question for you is, how do you explain the role of a forensic nurse examiner, law enforcement officer, or prosecutor to a survivor?
So I'll start with the forensic nurse examiner. I usually start by letting them know that this is the person who is going to conduct the exam, and with keeping in mind that this is not someone investigating the case, but that they may have to explain a little bit about what happened to them so that they can properly do the exam. So that means like checking for bruises, taking pictures, things like that. I want them to know that important evidence is collected by the forensic nurse examiner, and that, like I said, they're checking for injuries, offering medications that are important, and that all of the work that they're doing is coming from a trauma-informed place. So they're trauma-informed, and they're considering what has happened to them and how it's a traumatic experience. So again, they're not investigating, but they have to know what happened to you in order to do a proper exam. Of course, I'm missing a couple of things here that I normally say. I can't even think of my normal spiel that I give them. But with law enforcement, I do stress that they're going to have to ask the hard questions, and that it may be uncomfortable, which is why I offer them therapy right away. And I try to get them in with the therapist almost immediately, not the next day, but, we'll give them a couple of days to kind of get settled, kind of process some of these things, before they have to meet with the detective and, kind of go through this experience all over again. With the state's attorneys, I kind of let them know, or the prosecutor, that yes, you're going to have to kind of talk about this stuff all over again, that they'll have some of the notes from the investigators from law enforcement, but in order to prosecute, they're going to have to ask some of those questions again and kind of prepare you for what's next when it comes to a trial. That's usually the gist of it for me. I kind of usually arrange a meeting with the detective or the advocates from the state's attorney's office to kind of let them do their part, just so they can get familiar with the process and, just who they'll be meeting with and who they're going to have supporting them besides myself or my agency.
Great, thank you so much. So our next question is for all of you. So there's no specific advocate question, but from your perspective, what do you think is important for survivors to know about anonymous exams? So Stacey, we'll start with you.
I think a lot of these points were made, but just to know what the information is, I think it's most important in the hospital setting just to give people that option, because I think that there is sometimes a barrier to report. So if that option is on the table, someone might be more eager to have the exam done, or even to portion of the exam, whatever it is, if they know that they have that choice. So I think leading with that is really important in the hospital setting, just as an option if they're not willing to report right away, and just knowing that we can still do everything exactly the same. They can get the full exam, they can get the medicines, they can see an ER doc, they can all the things. It's exactly the same. We just don't attach their name to it until later when they're ready. I think it's also important. A lot of patients think that they can have the exam and it still goes to the crime lab if they don't report, and that's not the case. We're not running those kits. So I think that is probably the number one question I get in the hospital setting is, I'll decide to report whenever the DNA comes back. And that's just really not an option. So that's probably one of the main things they need to know.
Thank you. Mary, we'll hand it to you.
Well, typically I don't ever know or have a communication because at that point we're not involved. But I guess what would be helpful from a prosecution perspective regarding the anonymous exams for advocates to know is that, we don't get involved until somebody decides, as Jason indicated, that they want to go forward. What I think is so important, though, is if there could be the emphasis on the fact that the exam would remain anonymous until they're ready to go forward, because I worry that too many people don't report because they're afraid to have their name out there. And obviously, the best evidence oftentimes comes from the safe exam. And if we miss that opportunity, then the prosecution becomes much less viable. So it's really important for people to understand that, and if the victims are willing to have the anonymous exam done to preserve that evidence, that would be great. But I agree with Stacy in terms of the misunderstanding that their test will be submitted for DNA under anonymous thing. So I think that needs to be part of the conversation as well. Thanks.
Thank you so much. Jason, I'll hand it to you.
Yeah, so for when a victim goes in and has an anonymous exam, obviously that evidence, at least for our jurisdiction, we collect that evidence from the hospital. There's no identifying information on any of the evidence, but we collect it and it's stored in our evidence room until if there becomes a time when the victim decides that they do want to go forward with an investigation, we have that evidence and then we can switch it over to an active investigation. One of the things our department provides, and to the best of my knowledge, we're, if not the only, one of the only departments in the nation that do this. We're actually going to be presenting on it at the next EVAWI conference. But our department provides anonymous consultations with detectives for Jane Does at the hospital. So it's an option that's provided to them by the forensic nurse examiner. The victim is asked if they would like to have an anonymous consultation with a detective. And if they choose that option, we're on call 24/7. So whoever the on-call detective is that day, the hospital will then contact the detective and say, we have a victim who would like an anonymous consultation with the police. And so they'll put us on the phone with them, and then that victim can ask us any questions they want about the investigative process, what's involved in it, to answer any of those questions that may help them make a decision on whether or not they do want to go forward with an investigation. So, we've been doing this for about 3 years, and we found there were a lot of times that victims were reporting as Jane Does because of their fear in the investigation, or not knowing exactly what was involved. So by them being able to speak to us directly and ask us whatever questions they might have, helps them to make a more informed decision there at the hospital on whether or not they want to remain a Jane Doe. We don't ask them any questions. we tell them up front, the answers that I'm going to give you are somewhat generic because we don't know anything involved in their case. But we try to answer as best we can any questions that they might have about the entire process.
Thank you so much. Shanae, I'll hand it over to you.
Okay, so basically everything everyone else just said, but we do let them know that it will remain confidential and that it will be stored at our local sheriff's department. That's just where our kids are stored at, and that no one's going to reach out to them. It will have a tracking number, so it will not say their name, first name, last name, initials, nothing. It'll just be a number associated with the kit, and that there is also a tracking system and that they will be notified before the kit is destroyed. And then also we want them to know that the advocacy services are still there. So if you still want services, you still want support in any way, we're absolutely there to support you. But other than that, those are the main things and some of the main questions that they have when we speak to someone who has submitted an anonymous kit. I think that's it. Yeah.
Thank you so much. So moving on to our final question, this is once again geared towards all of you. So in your opinion, what do you consider the most beneficial aspect of sexual assault response teams, both for your profession or organization and for survivors? So Stacey, we'll start with you.
I think the response team itself, we meet regularly as a whole team, including MCASA, our local law enforcement, our state's attorney, everybody. We meet probably quarterly, I would say, from used to, not as much this year. But I think just having that collaborative effort helps with continuity of care for the patient. So they're, we all know each other. We can kind of communicate with one another. There's continuity along this process with them, and I think us being familiar with one another and having that close relationship, we're very tight knit in Harford County, at least. It's really nice because I can kind of talk up the next person, oh, this detective is awesome. You're gonna, this is gonna be great, or the state's attorney you're working with is amazing. And I think being able to talk up that next provider to the patient helps them feel like they have some confidence in what's going to be happening with their case and what's going on, and makes them have some kind of level of comfort with, the different handoffs that are happening, because it's quite a few between all of us, all of our hands in the pot.
Thank you. Mary, I'll hand it to you.
I would agree. I think the best part about the SART team response is to have that camaraderie and the ability to share information confidentially across the board, and to have the contacts to be able to pick up the phone and say, look, nurse examiner, can you help us out on this? Can you help us interpret this as we're getting ready for trial? Or to the advocate or responding person, we're having difficulty finding resources through our office and our advocates. Can you help us out here with housing resources or therapy resources? So it's really a victim-focused group of people who recognize that we depend on one another and we work with one another, and each person has their important piece of the process, and being able to come together in a room, we do it every other month, it is really important to be able to recognize issues, to share information. For instance, some of the things I've learned here today that other jurisdictions are doing, I'll be bringing back to my SART team to say, have we thought about doing it this way? We just want to, it's an opportunity for us to focus on the victims and to provide the best services across the board to victims in a cohesive manner. So it's I think a very helpful way of providing the best we can for our victims. Thank you.
Great, thank you so much. Jason, we'll pass it over to you.
Yeah, so I agree with what everybody's said already, and I won't reiterate everything. The one thing I can say from my perspective, or from the law enforcement perspective, and it's no secret, that in the past, law enforcement hasn't done a very good job with working these cases. We've gotten a lot better. We're continuing to get better, but one of the important parts with SART is being able to hear from the other people that we collaborate with on what we can do better, how we can do things better, how we can continue to grow and meet the needs of the victims on the law enforcement side.
Thank you so much. And Shemaine, I'll leave it to you to conclude.
Same. So, I was already working for the agency when I took over the sexual assault services, and we had to create this program from scratch because another agency had it and kind of just didn't do anything with it. So one of the most important things for me was to make sure that all of the agencies that support sexual assault survivors in Southern Maryland are able to communicate with each other. At first, it was all over the place. You didn't know who to contact. You didn't know what to do or which direction to go to. But since having the SART meeting and establishing those connections, we know what to do. There's never a moment where you're like, oh, who do I contact for this? Or what do I do now? We communicate very well together, and, having our SART meeting every other month, it just helps everyone stay on the same page. If there's ever a question, if we're not calling anyone out, but hey, this could have been done differently. We're all there to support each other. So the interagency collaboration has just went from nothing to this beautiful process. And I'm proud to say that because I had a little bit of doubt in the beginning. And anyone from MCASA that has helped us get this program together would understand where we were and how much progress we've made. So just like everyone else, it just feels great to know that you have support in other departments and other areas to help survivors.
Great. Well, thank you all so much for your answers and your expertise and everything like that. We really, really appreciate all of your time. So thank you again so much for being our panelists for today. We appreciate it.
All right, so thank you all for those of you who stuck around to watch the end of that with us. I posted the anonymous evaluation form into the chat. Again, we greatly appreciate all feedback as we are constantly striving to improve. If you are seeking a certificate of attendance or a certificate for social work CEU credits, you must complete the evaluation form. Upon submitting the evaluation form, you'll see a box at the top of your webpage containing a link. And if you click on that link, it will take you to the certificate request form. I'll be sending out a follow-up email later today with a copy of the video recording, all of the PowerPoint slides that were used in the presentation today, as well as the evaluation link. If you have any questions, feel free to reach out to me through email or by responding to the follow-up email later today. We hope to see you all tomorrow. Thank you again for coming.